Hello everyone, this is Urvashi Chauhan. Welcome to Courts Today by Live Law. We bring you the latest and in-depth legal coverage, coming to you with a brief of what all happened in the Indian courts today. Starting with the Supreme Court, which has agreed to hear on June 21st a plea filed by Enforcement Directorate against a Madras High Court order which permitted transfer of the arrested Tamil Nadu Electricity Minister Senthil Balaji to a private hospital. Balaji was arrested by the Enforcement Directorate on 13th June in connection with cash for job scam, which allegedly occurred during his tenure as the Transportation Minister under the AIADMK regime between 2011 and 2016. His family then moved a habeas corpus petition challenging the manner of his arrest and seeking permission to transfer him to a private hospital for treatment. Solicitor General Tushar Mehta mentioned the matter before the vacation bench of the Apex Court, comprising Justice Surya Kant and Justice M.M. Sondaresh. It was argued that a habeas corpus petition was not maintainable, and moreover, transferring Balaji to a private hospital was unjustified because, as per Supreme Court's decision in CBI versus Anupam Kulkarni, investigating agency will not get custody beyond 15 days from the date of arrest. The bench has listed the matter for hearing on June 21st. Also, the Madras High Court was set to hear the matter on June 22nd. Stay tuned for more developments in the matter. The Supreme Court today refused to entertain an appeal filed by the Union government against the Delhi High Court order, which had stayed the suspension of registration of certain private Hajj group organizers. The issue arose before a vacation bench comprising Justice Surya Kant and Justice M.M. Sondaresh. Assistant Solicitor General Sanjay Jain, appearing for the union, argued that if the private Hajj operators, which he described as delinquents, were permitted to carry on Hajj tours, it was the pilgrims who would ultimately suffer. However, the bench noted that as the matter was already coming up before a division bench of the Delhi High Court on 7th of July, therefore there was no need for the Supreme Court to interfere in the same. The Supreme Court remarked that the union should let the pilgrims go to Hajj without any psychological pressure of ongoing litigation. And now coming to an update on West Bengal Panchayat elections. The Supreme Court vacation bench comprising Justice Surya Kant and Justice M.M. Sondaresh has agreed to list tomorrow an SLP challenging the Calcutta High Court's order directing West Bengal State Election Commission, that is SEC, to demand central forces for all districts in West Bengal for the 2023 Panchayat elections. The matter was mentioned by senior advocate Meenakshi Arora, who argued that SEC can only make an assessment of sensitive areas and cannot send requisition. SEC has challenged two orders, one dated June 13th, which directed SEC to send requisition of the deployment for central forces for all the areas and districts which, in its opinion, have been declared as sensitive, and another dated June 15th, which directed for deployment of forces in all districts within 48 hours. The orders were passed on petitions filed by leader of the opposition in the West Bengal Legislative Assembly, Suvendu Adhikari. The state government has also filed an SLP in the matter, which will be heard along with SEC's appeal. Stay tuned. In another important update, the Delhi High Court has issued an order for plantation of at least 10,000 trees to utilize over rupees 80 lakh that were deposited in the court as costs imposed on the defaulting parties in different cases, including contempt and writ petitions. Stating that the benefit that trees would provide to generations of residents of Delhi by way of fresh oxygen would be immeasurable, Justice Najmi Waziri said that they would also serve as carbon sump to absorb in some measure the atmospheric pollution which plagues the city all year round. The court further directed that status reports with photographs be filed by the tree officer every 6 months and listed the matter for further proceedings on 7th July. The Jammu and Kashmir and Ladakh High Court has issued notice on a petition moved by Iltaja Javed, daughter of former CM Mehbooba Mufti, challenging the issue of a conditional passport that restricts the scope of her travel abroad. Iltija's passport is valid only for 2 years against the norm of 10 years and is valid only for travel to UAE for the purpose of her higher studies. In her plea, she has argued that the decision to issue her a country-specific passport with restricted duration is arbitrary and lacks reasonableness and fairness. She is also aggrieved by the top secret adverse report submitted against her under the Official Secrets Act by CID Jammu and Kashmir to the passport officer. The plea seeks for a direction upon the passport officer to treat her passport as valid until April 2023 without any endorsements restricting travel. Justice Sanjay Dhar issued notice to the respondent authorities and has directed them to file their response within 2 weeks. The matter is to be heard on July 19th. Stay tuned. A plea has been moved in the Kerala High Court alleging illegal encroachment of Sri Sarkara Devi Temple in Thiruvananthapuram by alleged members of Rashtriya Swayam Sevak Sangh, that is RSS, for conducting mass drills and weaponry training. The plea filed by two devotees and nearby residents of the temple avers that such action of the alleged RSS members is causing much agony and difficulty to the devotees and pilgrims visiting the temple, particularly the women and children. The petitioners submit that the respondents conduct illegal activities in the temple without any authorization from the concerned authorities and are using tobacco products within the temple premises, thereby affecting cleanliness, purity, and divinity of the sanctum. The petitioners submit that the Devasom Commissioner had issued 2 circulars so far to stop the illegal activities, but the violations still continue. The matter has been posted before the division bench comprising Justice Anil K. Narendran and Justice P.G. Ajit Kumar tomorrow. We will keep you posted with the updates. The Karnataka High Court has quashed a criminal complaint filed by a wife against her husband under Section 498A of the Indian Penal Code, alleging that he did not have physical relations after marriage on account of watching spiritual videos and thus it amounted to cruelty. A single judge bench of Justice M. Nag Prasanna allowed the petition filed by the husband and his parents and quashed the proceedings registered against them by the wife 28 days after marriage. The court observed that the decree of divorce was granted to the complainant on the allegation of causing cruelty by non-consummation of marriage, but non-consummation of marriage would not amount to cruelty as defined under Section 498A of the IPC. And if the proceedings were permitted to be continued, it would degenerate into harassment and abuse of the process of law. Government of Assam has informed the Guwahati High Court that 100 police stations have been provided with CCTVs and installation and commissioning of CCTVs has been done in 197 police stations. The division bench of Chief Justice Sandeep Mehta and Justice Devashish Barua was further appraised that all the CCTV feeds were being monitored at the centralized control center in Guwahati. The information was submitted by the State Advocate General D. Saikia in a hearing of a suo motu PIL registered following the incident of lynching of 2 accused persons to death in February 2018 after taking them out from police custody of Tezu police station in Arunachal Pradesh. As you know, the court had earlier directed the Advocate General to find out about status of CCTV systems in respect of the police stations in Assam. The Karnataka High Court has set aside an order passed by Family Court in which the wife's application to cross-examine her husband subject to a condition that she would bear his travel expense of 1,65,000 rupees from USA to Bangalore. A single judge bench of Justice Krishna S. Dikshit allowed the petition and said that putting a condition of the kind would virtually amount to foreclosing petitioner's right to cross-examine the respondent, that too in a serious matter in which her marriage is at stake. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us.